So Troy, thanks for joining us for
Pleasure to be here.
IRiQ Talking IR. You are Mr. IR, barrister to the stars. So we thought with the start of 2026, there's a lot that we can expect this year.
Indeed. I think one of the big issues in the industrial space is delegates' rights provisions. I think they're important for employers also. And the reason they're important is for employers understanding the rules of engagement and understanding what people can do, but what rights they also have. Now, a lot of circumstances you'll find if you've had traditional union involvement in a workplace and enterprise agreement coverage, that there will already be delegates' rights provisions within those agreements.
Yes.
So there might not be much change, but there also might be places where the provisions that have come in the Act are a bit different to what's in those agreements. So it's really important to know where you're starting from, and if you've got a good working relationship with employer representatives, but also union officials and delegates, it's important to get on the same page so that there can't be any confusion into the future about what's going to happen.
What else do you think is going to be a big item for this year?
There's been a recent decision in the Fair Work Commission about work from home and unfair dismissals. I think there's a lot to play out in that space. Working from home can be a double-edged sword, both for employers but also employees.
Yes.
And I think the reality is that with work from home provisions, there's probably instances where employers get more productivity out of their employees from being at home due to the flexibility they get. But I also appreciate that there are some things in that situation where employers might not think they're getting bang for buck, or there are concerns about the regulation of work health and safety and exposure to risks in circumstances where someone's not in an office environment, that you don't have control of those things. So
Yes.
they are legitimate, I think, concerns for employers to try and get that mix right.
Yes. And a lot of it comes down to the relationships in the workplace, the trust, knowing that everyone's been set up properly to be productive, having KPIs so people can be productive and you can measure that it works. But that trust aspect, I think, is something that sometimes means it doesn't work well. Yes.
So I think the reality is once again, not having a one-size-fits-all approach. Managing it properly, consultation in any relationship is always important. And if you've got work from home arrangements, having a constant check-in about making sure it's working for both sides, and if there are concerns, raising it early and addressing it.
Yes. Communication.
Indeed.
Another topical item for this year might be the 4-day working week. So flexibility with work. So the Launceston City Council has indicated that they're going to move to a 4-day working week. Employers are concerned that's going to set a precedence. The ACTU is understandably, it meets what they've been talking about for a while. There's always going to be a differing view, but the City Council sees it as something that can increase productivity. What do you think is going to happen?
Well, I think that's happened in that instance because there's been a meeting of the minds between the employer and most probably the relevant employees through their unions.
Yes.
So once again, I think you'll find that if there's going to be a move to those sorts of models, it'll be in circumstances where there's agreement between both sides.
Yes.
But I think there would be more than probably people know, a lot of arrangements where workers have 4-day weeks.
Yes.
Whether they're unionised or not. I do think it's important that, since enterprise bargaining certainly was introduced at a federal level, it was always about enterprise-specific solutions. And I think if at a particular enterprise that's a solution that works for everyone, I think you'll see it happen. If it doesn't work for everyone, it won't. And I think the risk in mandating it, once again, you are moving back to a model that since 1993 hasn't been how we've done business federally.
So Joy, anything else any sleepers, any, surprises we can expect this year?
Well, the Fair Work Act's been around since 1st of July 2009. I think the reality is, though, that the jurisprudence around general protections continues to evolve. And there are also a lot of new provisions in the Fair Work Act that were introduced through the Albanese Labor government since 2022. So I think that those things have still got evolution to have. And I think certainly with the Qantas decision, we've seen that there's been, I wouldn't say a new approach, but an emphasis on the fact that if you are found to take adverse action because people are proposing to exercise workplace rights, that's obviously a contravention of the Act. But I think there are different evolutions of that which may take effect.
So perhaps it will be, we might see some more precedent coming out through cases that just reinforce some of those changes to the Fair Work Act and
Absolutely.
the intention of it.
And I think also those who are not in this space, I think, underestimate how busy the courts and the tribunals are dealing with matters under the Fair Work Act, but also the state tribunals as well. So the law tends to evolve pretty quickly. An interesting decision I saw recently was a cost decision in the Federal Circuit Court and Family Court Division 2, where it was found that there shouldn't be cost orders against a union because it was effectively operating in the space or the role of a regulator, and that there shouldn't be a cost orders in circumstances where it might prevent a union from pursuing claims on behalf of their members in a vociferous way. So once again, these are new things that emerge. It's a single member of that particular court, but because there are so many cases coming through and our courts are so busy and our tribunals are so busy, working very hard to get decisions out, it does tend to evolve pretty quickly.
Yes. And the President of the Fair Work Commission has talked about the significant increase to the workloads and implementing new processes, the general protections jurisdiction. There are new processes in terms of being very clear as an applicant what the alleged contravention is, in terms of extension of time as well, purely because of the increase of applications that are coming through. Could we see that with unfair dismissal processes?
Well, I think a real driver in applications in the unfair dismissal space, and probably also the general protection space, is that self-represented litigants will utilise AI to generate applications.
Yes.
Now, it's good that it's efficient, and particularly the Fair Work Commission is set up for people to represent themselves. The inefficiency comes, though, when people are utilising those sorts of tools, but the answers they're getting in their applications are not particularly probative. Or they're just sucked out of the internet and put into an application.
Yes.
So what that then creates is a circumstance where if a respondent is legally represented, it creates more costs because you've got an application that might be nonsensical or deals with things that are not real cases. And also then generates more work for tribunals and courts, but more often than not tribunals where people are more often than not self-represented. That creates then more time in the litigation. So I think efficiencies might be looked at in terms of those things, but ultimately for practitioners like us, we should be informed by these things, but also remember that the right to be granted permission to appear in the Fair Work Commission or in state tribunals is permission that is granted at the indulgence of the tribunal. So that as practitioners, when we turn up, if we're arguing that the matter will be more efficient because we're appearing, efficiency should always be at the forefront of what we do, because a discretion has to be exercised to allow us to appear. So when we do appear, we should be thinking about the things that we can do, not only to protect our clients' interests, but in a way that does what we say we're going to do, which is makes the process more efficient.
Joy, thank you so much for coming in and joining us for IRiQ Talking IR.
It's a pleasure. Thank you.